Welcome to Property Law 101. I'm Sara Bronin, and I created this series to help you understand the basics of property law through thinking about four big questions. And today we are talking about the fourth question, which is holding interests in property. In another video, we dealt with the general concept of title and how to prove ownership. Today, we're talking more specifically about title in land. To prove you have title or ownership in land, in the vast majority of cases, you need to have a written deed. A deed is a document that purports to transfer real property. It identifies the parties, describes the property, states the grantor's intent, and is confirmed by the grantor's signature. The elements for the specifics of the deed are set out in state law. So one of the four important elements in the deed that we've just outlined is how land is described. So traditionally, land was described with metes and bounds using natural objects like rocks or trees or other existing structures to establish the boundaries of property. There is one big problem with metes and bounds, as you might imagine, and that is that these kinds of objects tend to move. That said, many legal descriptions today retain these references, whether the objects are there or not. Nonetheless, metes and bounds is an important way of describing property. An alternative is a more formal adherence to the US government survey system, which is used very often in states out west. As the United States expanded outward, surveyors plotted land based on meridians running north and south, baselines running east and west. I should note that this system of measurement has somewhat questionable roots. Consider the video where we touch on the doctrine of discovery and the Johnson versus McIntosh case. When early Americans used the doctrine of discovery to declare they had title to Native American land, they needed a way to make this title marketable and to confirm that in fact they owned it. In other words, they needed to find a way to reduce their conquest into some tangible form. That's really what motivated the US Land Survey. However the land is described, whether it's metes and bounds or through adherence to the survey, it's usually mapped. For divisions of property, subdivisions, developers will create a larger map beyond just the individual property map. This larger map is called a plat, and it will describe how land will be subdivided. The plat will be recorded in the land records, as will, of course, deeds themselves, if a property owner is smart. We'll cover recordation in another video. So we've talked most today about the description in the deed and relevant maps, but remember that the deed itself has other elements. In addition, for a deed to reflect a valid transfer of land, the grantee or the receiving party also have to accept it. The manner of acceptance is set out in state law. With that, I'll leave it there. I'd love to hear from you on Twitter or through my website where you can sign up to my mailing list. See you next time.